So, welcome everyone. Thank you so much for joining us today. My name is Valerie, and I'm one of the associates here at Howie Saxon Henry working on the Mass Tort Class Action Group. We are very happy that you were able to join us for today's webinar. We wanted to hold this general information webinar for both current client of ours and any potential women out there who are looking to get more information about the cases that we are doing here at Howie Saxon Henry. Just a general reminder that this webinar is designed to provide general information only, and it does not constitute legal advice. We are also, unfortunately, not in a position to represent anyone living in Quebec, and I wanted to make sure that that was information that you had up front before we got started today. I am joined today by my colleagues, Renee, Megan, and Victoria. And I want to take a few minutes to introduce you to them before they get into the presentation. We have slides that will take us about 30 to 40 minutes to get through, but we wanted to make sure that we did allow time for any questions at the end of it. So if you do have questions along the way, please feel free to type in the chat function at the bottom, and we will try and get to those. So as I mentioned, I'm here today and joined by my wonderful colleagues. We have Renee and Megan, who are both partners here at Howie Saxon Henry and have worked here together for the last 15 years. Renee is a certified specialist in civil litigation. She's also been recognized by best lawyers in Canada in her field. And in addition to being a lawyer, Renee has been a registered nurse for over 30 years with experience in both the United States and Canada. And it's really her medical knowledge and legal expertise that are quite a unique combination that allows her to approach each case from her client's needs and long-term quality of life. We also have Megan, who is also a partner at Howie Saxon Henry. She is joining us from Halifax today, where she has been working remotely during this pandemic. Megan has been at Howie Saxon Henry since 2004, and her practice includes nursing home negligence, medical malpractice, as well as catastrophic motor vehicle accidents. She is also the current chair of the risk management team of a national charity called Shelter Movers, and Shelter Movers provides free moving services for women fleeing domestic violence. And last but not least, we are also joined by Victoria Yang. Victoria is a graduate of McGill University and completed her law school here at the University of Toronto. She went on to work at a corporate firm in Toronto before joining Howie Saxon Henry's class action and mass tort team 2 years ago now. And she is currently the lead associate on a number of our class action and mass tort claims here at Howie Sax, including the talcum powder ovarian cancer litigation, as well as the Allergan breast implant mass torts. So as I mentioned, we're here to cover some general information. This is the overview of the topics that we're going to cover. If you ever need to step out, as we know, the days are busy lately. This is being recorded, and we're more than happy to provide you with a link to both the recording and the PowerPoint presentation after if you ever need to step out. And so without further ado, I will turn it over to Renee.
And this litigation is important. We have power in numbers, and we just want to make sure that we represent as many women affected by Essure as we possibly can. So you probably all know what Essure is all about, but I'm just going to hit the high points of what it was marketed as. It was marketed as permanent female birth control with a 99.3% effectiveness rate of preventing pregnancy. It was designed to remain securely in place for a lifetime. And it was, the idea was, this is a minimally invasive procedure where they can be implanted going through the vagina, cervix, through the uterus, and into the fallopian tubes. Once placed in the fallopian tubes, these coils were supposed to cause an inflammatory and fibrotic response that caused scarring and tissue growth that would make a permanent barrier in the fallopian tubes, thereby preventing pregnancy. What happened not in all cases, but in many cases, and I'm sure that's why you're joining us today, is that there were a number of complications and adverse effects from Essure. migration of the devices, perforation of the fallopian tubes, the uterus, migration into other areas of the body, as well as ectopic pregnancies, unwanted pregnancies. Of course, with this came chronic pain, prolonged and severe bleeding. There were times that the implants themselves fractured after they had been implanted, causing another concern versus severe, with respect to, I should say, severe allergic reactions, these metal reactions, copper, for example, autoimmune type reactions. And there's so many more that I'm sure each of you could list, another 5 symptoms that you had that were related to Essure. This all sort of got approval by Health Canada and the Food and Drug Administration. Starting in 2001, Canada approved it, and then the United States FDA approved it in 2002. And it was based on studies conducted or clinical trials that were based on 12 to 24 months of monitoring after implantation of the Essure coils. But beyond 24 months, the nature of the body's cellular and fibrotic responses to these microinserts and the ability of the devices to maintain the occlusion of the fallopian tubes, that was unknown. And as it turns out, many of the complications were unknown when it was put out into the market. Now, Bayer, originally it was Conceptus who put this product out on the market. Bayer later bought Conceptus out, and they had an obligation, though, under the Health Canada regulations and the FDA regulations. They had to establish and maintain procedures for receiving, reviewing, investigating, and evaluating complaints of adverse events. But Bayer also had to report complaints of adverse events in a timely manner to Health Canada, particularly where there was incidents of device malfunction, such as the fracturing of the device, the migration of the device, and unplanned pregnancy. And what we do know is that there appears to not have been the reporting that was required under the regulations. And as it became more evident to Health Canada that there was a problem with the reporting and with this device, in 2015, early 2016, Health Canada conducted a safety review. They recommended at the end of that safety review that there be increased monitoring of the safety of the Essure system. And they, vowed to work closely with the manufacturer to issue a risk communication to help clarify information about the device and associated safety concerns. They were going to also work with the manufacturer to strengthen product labeling for Essure. It was clear that women who were being implanted with this device were not being given enough information about the risks and benefits associated with the coils, and therefore may not have been receiving the information required for them and their doctor to make an informed decision about whether to proceed with this type of permanent birth control. So in 2017, however, because there were significant reduction in the number of women who were willing to undergo Essure implantation as the news got out, and doctors were less willing to recommend this type of a permanent birth control, the Bayer just kind of they said it was a business decision to discontinue the sale and distribution of Essure in Canada. They presented a statement saying that this decision was taken for commercial reasons and the favorable benefit risk profile of Essure remains unchanged. This is not a recall of the product from the market. While that's what they said as their PR message, the reality is that sales were going down because this was a product that people knew were a problem that was problematic, and it wasn't going to continue to sell in Canada based on that. Not to mention the fact that Essure had already been discontinued in Finland, the Netherlands, the United Kingdom, as well as other countries. And as well, it had been suspended and recalled in Brazil. Megan, are you this one?
Thanks, Renee, for giving us that brief background. Again, information that I'm sure a lot of you today already have, but just a background as to where we are coming from in terms of these lawsuits. So Victoria, why don't you lead us through the next set of slides? So Victoria is going to take the time to explain why it is we're bringing these lawsuits and in what manner we are bringing them.
Yeah, of course. So I'll be going over kind of what a class action is and what a mass tort is and why one may be more preferable than the other in the circumstances we have here. So first, to go over class actions. In a class action, there's usually only one or a few representative plaintiffs that represent the best interests of the entire class as a whole. So only that representative plaintiff generally communicates with the lawyers, they give instructions to lawyers, and they present the case to the court. So everyone else just falls under that class. At the end of the class action, whether there's a settlement or it goes to trial and is successful, all the class members obtain compensation. But they're largely absent. The class members are largely absent throughout the litigation process. And you can't decide the course of litigation either. Class actions are a really powerful mechanism in certain circumstances, but in cases where damages are really significant and when there's a large variation in the individual circumstances, pursuing cases on an individual basis or a mass tort may be the preferred mechanism, and I'll discuss that a little bit later. Class actions can also potentially take longer because there's an extra step in the litigation process. It requires a certification hearing as a first step. And what that is it's for the courts to determine that, this is a case that can effectively and efficiently proceed as a class proceeding. And that needs to happen first before any other step of litigation happens. So next, with the mass tort, in a mass tort, there are multiple simultaneous lawsuits, all against one common defendant relating to a single common triggering event. So here, what we're looking at is, multiple women bring individual claims against Bayer due to injuries and damages resulting from Essure. So I'll go through some of the advantages in pursuing a claim through a mass tort rather than a class action. In mass torts, we don't have to deal with that extra certification step that I mentioned earlier, which means we can move forward with that litigation process earlier and get documents sooner as well. As well, each individual plaintiff can directly decide the course of litigation. If there's an offer on a table, you can decide whether to take it, make a counteroffer, or reject it and move forward with litigation. You would be the one instructing us on your matter. You still retain the benefit of strength in numbers, as all the plaintiffs will be going against a common defendant. So you'll be sharing expenses, expert reports, stuff like that as well. So there's still that advantage. So what we're doing here is a mass tort, and there's several reasons why we're taking this approach. Here we're dealing with very sensitive and significant injuries. We're dealing with, loss of income. We're dealing with different effects in health. We're looking at different factors here. Everyone's of different age, different health backgrounds. So because of this, we think it's really important to understand each individual's circumstances in deciding compensation. It's also really important in our opinion that each individual have that choice to decide whether compensation is reasonable or fair for them. I'll go over next some of the other litigation that's been going on involving Essure. In the US, you might have heard on the news that Bayer has agreed to settle claims against them for a total of $1.6 billion. You probably heard that, Bayer has made statements saying something along the lines of, they're going to vigorously defend their claims in Canada. But what does that mean for us? It's really, really hard to tell because just because they've settled in the US Doesn't mean that they're automatically going to settle or want to settle in Canada, but it also means, on the other hand, that it won't be settling in the future. It's very much a likelihood as well. So it's really, really hard to tell right now what that means, if there's any implications. In terms of the class action, there is a proposed national class action being brought forward in Canada, McInnes and Bayer, Inc. It was brought by Merchant Law, and it was brought in Saskatchewan courts. It was not successful, so it was not certified. At this point, we don't know if they're going to try again for certification, and if so, when they're going to do that. We don't know that yet. So what that means for you, if you do decide, or you have, already joined our mass tort, this is just something to keep on your radar, and this is something that we'll, also be aware of and let you know of as well, and keep you updated on. If the class action does get certified, it just means that you will need to opt out of the class action, and we will certainly help you with that process when it comes.
Thanks, Victoria. So yeah, just some subtle but often very important differences between pursuing cases by way of a mass tort or of a class action, and our firm does do both, and we often approach cases right from the get-go, analyzing whether we feel that this should be a class action or a mass tort, and we did feel right from the beginning that given the severity of the injuries that Essure has had on people implanted with it, that this was a case more favorable to the mass tort approach. So I will turn it over to Megan, who is going to go over briefly how our retainer process goes and what it means to be involved in a mass tort litigation with our team specifically.
So thanks for joining us today. We're sort of flying through what we had prepared to share with you. This webinar is designed, and I think Val mentioned this originally, for people who are already our clients, who are already convinced, that the mass tort is the way to go and that have joined us. And we have over 100 clients across the country now. But it's also designed for people who don't know that they have legal recourse. This webinar is designed to answer questions. And so we hope to have you, share your questions or your concerns or your comments with us so that we can address them in this forum. So again, just to reiterate what Victoria said, what we are doing, unlike Merchant Law in Saskatchewan, is bringing these individual claims because you've all suffered differently. You've all been impacted differently. And so rather than the court with one sort of broad sweep deciding what the value of everybody's pain and suffering is, or income loss is, or what the impact has been on their life, we like to be your voice individually in order to represent you and how your life has been impacted. You're not just a number in a class action, you're an individual who has suffered, and Bayer should be held accountable. So that's sort of how we, as your all-women legal team at Howie Sachs and Henry, are approaching these cases. So I've spoken with many of you about this particular process, the process of retaining us to represent you. In order to do that, there are some qualifications that have to be met. Again, that you may be familiar with, but one is that you had to have had the Essure implanted before October of 2016. Renee mentioned some of those warnings that were changed in late 2015, early 2016, and so that's one of the reasons that particular criteria exists. Warnings were changed around that time. Obviously, you need to be experiencing symptoms. I think all of you probably have experienced some sort of symptoms. And some of you may have seen the Fifth Estate recent program that was on this week. And Renee from our firm spoke on behalf of our clients with respect to the litigation. And one of the things that I hear very frequently from those of you who I speak to, from the comments I see on the Facebook pages, many of you were made to feel that these symptoms were not real, that they were all made up, that they shouldn't be taken seriously. And so the strength that I see in the comments on the Facebook pages and the comment that Renee had made, in the Fifth Estate segment about the fact that many of you felt crazy not believed. That's just not right. That's just not true. You have suffered. And so, of course, one of the criteria would be that you've experienced symptoms, adverse symptoms, unexpected symptoms as a result of the Essure implantation. And then the third criteria is that you've either had the Essure removed or that it's recommended to be removed. The removal surgery is one that many of you have gone through, sometimes not just once, sometimes several times. A less invasive procedure in the hopes of having the coils removed, and then often, unfortunately, a more significant surgery, the hysterectomy. Sometimes your coils haven't been found where they ought to have been, and you've had to have more invasive procedures as a result. Many of you live in remote parts of the country. Many of you have difficulty finding a surgeon that will help you to remove the Essure coils. And so we accept those of you who not only have had it removed, but who are pursuing removal as well. Those are the three real criteria. Thanks, Val. So the first step in coming to us is to reach out. We don't have big national ad campaigns. That's not how our firm works. A lot of our clients come to us through word of mouth, through sharing in Facebook pages. So we'll ask you a series of questions when you reach out and figure out where you've had the Essure implanted, ask details about your personal effect. How has it changed your life? What have you experienced? This is critical. This is unlike a class action where you're automatically included. In a mass tort, we are individually retained by each of you. We open a file for each of you. And so it's important that you reach out. You're not automatically included otherwise. We send to you, after we understand that you qualify, a contingency fee agreement. What that means is that we don't get paid anything up front. There is no charge to speak with us. There's no charge to see if you qualify, to ask questions, to consider your options. We charge only at the end of a successful lawsuit. And so that's important. I know a lot of you have concerns. You may have already suffered economically because of this, or you may not be in a position to pay a lawyer by the hour, which a lot of other types of lawyers do, charge by the hour. We charge, again, a percentage of the recovery at the end of the case. So after somebody from our team reaches out and finds out whether you meet that criteria, you have a meeting with a lawyer on the phone. You can ask questions. We explain to you similar things to what I'm saying now in terms of how we are paid, how we work, what the difference is between a mass tort and a class action to make sure that you feel informed. You can make a decision that's best for you. Then, if you wish, that's when we send you the contingency fee agreement. That is a document that walks through what we will do for you, what we expect of you, which is really just to be available to give us instructions when we need it, to keep us updated on your condition or any developments. And in terms of what we'll do for you, it includes collecting your medical records, analyzing them, sending them to the experts if necessary, following up with you. So those are things that we'll send to you to review to make sure that you're comfortable with. And when you sign that contingency fee agreement, you send it back to us, we open your file and we get to work. Unfortunately, these cases take years, especially against a big corporation like Bayer. It takes time to collect all the medical records and do all that analyzing I told you about, to advance the claims, to walk through the steps of the litigation. The steps of the litigation include issuing statements of claim. So we've already begun that process for many of our clients across the country. We issue the claims in the province in which you live, in a particular city, and then they are served. Your statement of claim is served on the defendant, Bayer. The statement of claim includes a value that's crazy. If we don't ask for a lot and it's just a standard amount across the board, it's more difficult to change the value later on. The particulars included in the statement of claim are broad. They include all of the impacts that Renee mentioned to you. Even if you may not have suffered those, I know a lot of you continue to suffer and continue to realize different impacts that you may not have realized yesterday, or that you may not experience until you get older or have different life experiences. And so we claim them in a broad way. After the statements of claim are issued and served, then they will be defended by Bayer. They have not to date in Canada, but they will be defended by their lawyers. And then we will go through a process where we produce the evidence that is needed in order to prove your claims, your medical records, expert reports if needed, income information, and all that sort of thing that will prove what the damages are in your case. The types of damages that we claim for our clients all across the country include general damages. So those are damages for pain and suffering. And again, this is a reason we feel strongly that this should be a mass tort case, or that we offer that opportunity to our clients, because everybody has been affected differently. Everybody's pain and suffering is different depending on how it's impacted your life. We can also claim for special damages. As I mentioned earlier, loss of earnings, out-of-pocket expenses, medical expenses you may have had to incur as a result. And we can also claim for aggravated and punitive damages. It's really rarely awarded in Canada. Would usually require a trial. And just so you know, most of these cases resolve outside of a trial. And I don't mean most of Essure cases, I mean most litigation in general, most personal injury cases, they settle outside of a trial. And so without a verdict, punitive or aggravated damages are unlikely. But we do claim those because we want Bayer to know that if push comes to shove, we end up in trial. That will very much be a live issue. Again, we like to keep the pressure on them. In any case, there are risks. There is never a guarantee. We are confident about these cases. We're confident about the evidence against Bayer. We are in close contact with counsel in the United States that have entered into these negotiations with Bayer. We can never guarantee a result. Canada is different. There is a different system here. And so we cannot, as Victoria said earlier, we can't rely completely on what's happened in the United States. What we need to prove in any case, but in this case, is negligence. We need to prove that there was a party at fault, that Bayer did something they ought not to have done. We need to prove causation. We need to prove that what Bayer did, the negligence, caused the damage. And then we need to prove the damages. What has the impact been on you as an individual? So again, negligence, causation, damages. That's where the whole, am I making this up, am I crazy comes in. That's the causation question. What did the negligence cause in terms of the damage you experience? Because we can bet that a defendant will say you would have experienced those things anyway, or those things were caused by something other than the Essure device. As the doctor said on the Fifth Estate that was interviewed, she says, seems a little bit strange that this many women are experiencing very similar symptoms if it's all made up. What if the cases don't succeed? That's another common question that people have and that I would be concerned about as well if I was in your shoes. The contingency fee agreement that we send to you says very clearly, if we don't succeed, if you don't get paid, neither do we. There aren't any financial implications or downside to you to starting this action. You were wronged, you have suffered, you have a right to claim. There may be risks down the road if we're forced to go to trial, if Bayer makes an offer to settle that is not accepted. Those types of risks will be very clearly spelled out for you because again, you are an individual client and you deserve to know exactly what your risks would be going forward. But like I said, our firm is confident We do see the example in the United States. We know that most of these cases resolve outside of a trial, and we don't tend to take on losing cases. So we will be sure to talk with you about any risks when and if they arise. For now, we're risk-free. When we get further down the road, when Bayer defends the action, and after we've gone through production of what your case is like, and how we pursue your case, how we present your case, then we start to talk about resolution. And that could come in many different forms. It could be through informal settlement negotiations. It could go through something called a settlement blitz, where we basically go down a list with Bayer and talk about what the value of the individual cases are. It could be through a little more formal process called a mediation, where an expert mediator is hired to help see if the cases can be resolved through negotiation. So there's a lot of different ways that we can enter into these settlement negotiations. And you will be informed throughout. One thing I should mention, and I do often when I've spoken with you on the phone, is the fact that we at Howie Saxon Henry are continuing to work on your case in the background, even if you don't hear from us every week or every month. We give you updates as we become aware of updates, as things change, either in the US or in Canada, and we try to keep you in the loop in that respect. But I usually tell people, you are responsible for your life, for carrying on, for surviving, for overcoming. We're responsible for your lawsuit. So we won't tell you every time we send out a letter or we get a letter in, or that we're following up with your doctor for medical records. We will keep in touch with you every 5 or 6 months, or maybe more frequently if there are developments. So don't feel just because you don't hear from us that you've been lost in some way. You are important, and we continue to work on your case, even though you don't hear from us. One of the things that's really so important here, and I can't really emphasize this enough, although I think I mentioned it earlier, is the fact that it's difficult for us to get the word out to other women that we're trying to help, and that we are still taking on new cases and new clients. And then without pressure, we're happy to speak with you. But we do hope that you will share this information about what we are doing with friends, with colleagues, with other women that you hear mention the word Essure. Like I said, there's no cost to have those initial consultations, or frankly to pursue a lawsuit until a successful resolution. So sharing our contact information, reaching out to us with questions, with concerns, with ideas. We really are a team, and we are happy to address all of those issues with you as we progress with this lawsuit.
Thanks, Megan. So we know that was a lot of information thrown at you, but we wanted to give everyone, like we mentioned, both current clients who have been with us for a number of years now and potential new clients, just an idea of what the lawsuit is going to look like and what we're working towards. These lawsuits do take years. So just to give you an example, the transvaginal mesh cases that we are working on against Johnson & Johnson, we started with about 200 cases, and we have been able to settle 150, leaving us 50 to go through next steps. And there's just times in the process where we might not give you as much detail about what an examination for discovery is, for example, until we actually get to that stage, because we just want to make sure that we're giving you the information for the stage in which your action is at. So I'm sure this will not be the last webinar that we do for our clients, giving more information as the case develops. So we'll move on to a few question and answers. We are very much on time, which is always great. So one question that we got, and we're going to turn this sort of into a free flow discussion now. So Megan, Victoria, Renee, feel free to jump in. So one question is from a current client, and the question relates to, you know, when they first sign up with us, we ask them to complete a very brief survey that lists their symptoms. And the question is, you know, will there be other opportunities to go into a little bit more detail for those people about the actual impact that their symptoms have had on their lives? Because from their perspective, the only thing that we have right now is this survey.
I'm happy to jump in just for a minute. One of the things that we would love to have from you is a deeper understanding of what the impact has been on your life. But don't forget that initial survey was to help us understand generally if you meet our criteria with a little bit more detail. We do seek medical records, and the medical records have in them a whole lot more detail than what it is that we initially received in that survey. So please feel free to provide more details to us that we will include in your file, that we'll review when we're considering your case and when we're advancing your claim. But don't think that that's all that we have. When we do request those records, we're going through those as well to help us understand your story.
Yeah, and I think when we talk about evidence in a case, evidence comes in different forms, right? Evidence comes from your medical doctor's records, and then if needed, it will also come from you. So the examination for discovery part of the case is where you actually get to speak, and your verbal evidence is used alongside your medical evidence to provide the defendant with both, objective in terms of these are the things I reported to my doctor, these are the diagnoses that I'm getting from my medical provider, and the more subjective, whereas no one else knows your pain, no one else knows your day-to-day life, and so you are the person that's in the best position to provide that type of evidence. So both are types of evidence, just different. Another question we are getting is if someone doesn't have, a clear loss of income, but they passed up on opportunities to earn income, for example, how is that going to be dealt with in the lawsuit?
I'll jump in. It's one of the more difficult claims to actually prove, unfortunately, unless you've somehow been able to document these opportunities, these promotions that you perhaps applied for, but didn't, you didn't land that promotion because you were unable to work. The problem is that sometimes the employers who were going to give you that job or who you were qualified to fill a position, they may not cooperate with efforts to explain that you really were in the running. And for whatever reason, if they are very reluctant to say it was due to health reasons that you were not selected. They fear for their own negligence or impropriety in that respect. So that becomes a bit of a battle, but just because it's difficult to prove doesn't mean we won't pursue it. And so any records that you can keep, recording your efforts to, for example, find work and being turned down, applications that are filed, interviews that have gone forward, but you weren't selected for the job. Whatever the case may be, those experiences, because your memory will fade, those experiences are important for you to document so that we have a clearer understanding. And that information can also be developed further in the appropriate cases by way of an expert who can look at the vocational impact on your ability to work or to advance in your field, or whether you've got a loss of competitive advantage as a result of the time off work associated with Essure.
So the other question relates to, I'm going to ask it in two parts just so that the difference is clear to everyone listening. What's the difference between someone retaining us to represent them in a lawsuit against Bayer and actually starting a lawsuit? And then the part B to the second question is how long does Bayer have to respond to the lawsuit once it's been filed?
I'll just jump in and then I'll let somebody else answer the next question. So if I understood the question, once we're retained, what's the difference between being retained and commencing the lawsuit? Is that okay?
Yeah.
Well, what we do is once we're retained, there's key information that we have to obtain either from you directly, because some of you will have the information we need to commence all our lawsuits on your behalf, but others of you may not have the identification or lot numbers for the Essure coils. And those are important information to put into the statement of claim. So we gather those medical records required to have complete information. We then draft the statement of claim, have it issued and served across. It's actually served against the defendants, not only in Canada, but in the United States as well. Then how long does BEAR have to respond? Well, the defendants who are outside the country, outside of Canada, generally have about an extra month to over what the defendant here in Canada would have. So I would say generally we'd be looking at 20 to 21 days for those in Canada, and possibly an additional month beyond that. So 45 days perhaps is a good estimate of, or 50 days is probably a good estimate. We suspect that BEAR, knowing that more claims are coming, will probably start. They probably already retained counsel, but they haven't contacted us yet. But these are going to be done, these defense or statements of defense that they are going to be serving on us will be the same in every case. They'll just be like a template that simply responds to each and every allegation. And so it's a matter of, they're just going to do that en masse. They may come, within weeks or a few months of each other. And then at that point, we're in the discovery phase of the situation where we have to start producing, and they have to start producing the records, the documentation. We produce the medical records that's proving your losses, but they have to produce the underlying decision-making documentation and the investigation that they did, how they recorded these adverse events. It's a lot of information that they are going to have to gather and produce for our review in that discovery process. So even if they don't meet the deadline after they've received our statement of claim, if they don't get us a defense within, say, 50 days, that's not fatal to the lawsuit. There's a lot of give and take in these initial phases, especially when there are so many claims being issued and needing to be defended at the same time. So they may, it may be that we get them in 3 months' time or whatever the case may be, but that doesn't really cause a delay in the litigation. It's just part of the process when you have so many claims proceeding at the same time.
Yeah, and the other thing that might happen as well, which we've seen in our other cases, is they might be asking for what's called a demand for particulars when they get our statement of claim. And that's essentially asking for just a few more details so that they can adequately respond to each statement of claim that they have been served with. But like Renee said, these things are done on a rolling basis. And again, just because they don't send us a letter or an email within the 45 days, it doesn't mean that we are going to go ahead and note them in default. It's there's just a collegiality between the lawyers on both sides of the case, where we give them time to prepare their statement of defenses, just like they are giving us time to prepare our claims and prepare the medical documentation. So it does take time. Sorry, I was just trying to read the next question, which is a good one that we have addressed with people before, and it is unfortunate how much this product has affected not only the women that were implanted with it, but also their families, their husbands or partners, their children. So the question is, are those other family members able to join in the lawsuit? And if not, sort of what is the reasoning for that? Unfortunately, right now, we really are focusing just on the actual people who received the implant and who suffered the injuries. Um, the, the law across Canada for damages for Family Law Act claimants, that's the term that we use here in Ontario because we actually have Family Law Act legislation that allows to bring those damages, but the law is really not uniform across Canada. And so it would really be depending on where you live, whether you're allowed to claim that compensation. But right now, it's a strategic decision we've made to sort of streamline the cases. It's certainly not because we are not sympathetic to what this product has done to not only you and to your family, and you really all have our sympathies for what this has put you through and put your family through. But strategically for the lawsuit, we are just focusing on just the women. Now, these things take a really long time and these things take years. And so if we ever feel like we're in a position to start including family members, we can certainly amend the claims and pursue that on individual cases if that's the case. But for now, we are just focusing on the women.
I think one of the important things that I just add to that, Val, is that if, again, going back to the individualness of your claim, of how it's impacted you, if it has impacted your relationship, your intimate relationship, the security of your relationship, if it's ended relationships, if it's caused, any sort of family dynamic changes, those are all things that are included in your story, in the woman's story as well. So your pain and suffering, your claim for general damages is impacted, not only by dollars and cents in terms of income loss, but in terms of what effect it's had not only on your own pain, physical pain, but the emotional pain you've sustained, the effect on your relationships as well. So that's definitely part of your story. That's part of what we'd like to hear from you in terms of that individual impact on you, in order to properly advance or assess the settlement value, the value that we would pursue from the defendants in the case, again, depending on your individual circumstance or the effect on you as an individual.
So yeah, definitely, as Megan said, that is definitely information that we want to have in order to start individualizing what your individual pain and suffering has been. One more question before we start wrapping things up is moving forward, clients who have retained us, what's important for them to do? And so say they've had surgery already to remove it. What's an important step for them to take throughout the next few years in terms of their treatment providers to make sure that things are documented properly and that we have all of that documentary evidence for their case?
I can jump in here. So any treatment providers that you see, keep us updated because we will be we'll need to request those records for your file. It's all part of, understanding your circumstances better. We can help you better if we're able to understand and know, what's going on, what you're going through. So definitely keep us updated. Let us know when you're seeing new treatment providers. If you're moving, new phone numbers, new addresses, we want to be able to reach you. We need to, get instructions from you or I give you updates. So definitely that would be really important.
It's just important that you see your doctors regularly and that you tell them what's going on with you. If you tell your doctor what's going on, chances are they will record it in the records. It's not a guarantee because some doctors record things and some doctors don't record things as well as others. But I think it's very important that you don't go 6 months without seeing a doctor. And the other thing is that any treatment that can potentially help you, we encourage you, if you have the financial wherewithal, or if it's funded through your provincial healthcare program, we encourage you to at least try these potential treatments and see if they help to improve your situation. Because there's a requirement in law that you as plaintiffs do your best to try to what's called mitigate your damages. try to get better, which all of you have through all the suffering. That's exactly the point. You've done everything you can and have been met with a lot of obstacles to getting the treatment that you require. But those of you who have had some improvement after removal of Essure and are in a position to now potentially look for work, showing that you're making efforts to return to work, applying for jobs, efforts to, after COVID, get back to some sort of a life that is, normal, whatever that means after COVID. And then these are all things that just show that you have been dealt a horrific hand with these Essure coils and with their adverse effects, and that despite it all, you're still kicking and you're still doing your best. That goes a long way in helping us to prove your damages. And so, I know it's probably hard to keep the faith, so to speak, to be able to, keep your chin up after so many years of struggling. But, we just encourage you to do as much as you can in your particular circumstances to help yourself. And we'll take care of making sure that we present your case as effectively as we can to recover as much in damages as is possible.
So I do see that there's a number of other questions, and I'm just not sure if we're going to be able to reach them all because I do want to be mindful of the time. So I personally am able to see who has asked these questions. So what I'm going to do is I will send you an email personally so that we can touch base on those individual questions, because some of them just turn on individual facts that might not be applicable to everyone. And if I don't already have your contact information, please do email the Essure lawsuit at hshlawyers.com. That's our general Essure email address, and all of us have access to it. So between myself, Megan, Renee, and Victoria, you'll be able to get a hold of us relatively quickly. So with that, I think we will wrap things up. Thank you so much for taking the time to join us today. And we're really looking forward to continuing to fight this case on your behalf.
Thank you all.
Thanks for joining us.